Hello, everyone, and thank you for joining today's presentation brought to you by the SLW Institute, which was developed by the Schwegman firm to deliver educational and training content to advance your IP knowledge. My name is Brian Ness, and I'll be facilitating today's webinar. To kick it off, here are a few housekeeping items. If you have any questions during the presentation, we encourage you to use either the Q&A or chat feature. Also, we'll be sending a follow-up email tomorrow that provides a link to the recording of this webinar and a copy of the PowerPoint presentation. For today's presentation, Dennis Ostrowski will compare claim scope and application support for U.S. and non-U.S. jurisdictions. Dennis, I'll let you introduce yourself and take it from here.
Thanks very much, Brian, and thank you all for joining our webinar. My name is Dennis Ostrowski, and I'm an associate here in the chemistry practice group at Schwegman, and my practice spans a wide variety of technologies, all related to chemistry and materials. And as Brian said, we're going to be discussing what's needed to support claims in non-U.S. jurisdictions. Applications are often drafted with the U.S. in mind, but often can find themselves in foreign jurisdictions. For example, you can use a U.S. specification as a PCT application, or a U.S. application is a priority document for a PCT application. So although the requirements are generally similar as in the U.S., which is good, there are some differences that can have a significant impact on the claim scope you can ultimately get if you're unaware of them. And when we say support, what we mean is, can you point to something in the application that adequately by the standards of the jurisdiction that you're in, adequately describes the claim feature you wish to include or the argument you wish to make? So by point to something, I mean, are there words or are there pictures, figures in your specification that you can point to? Now, obviously, this is a really large area of IP law, so we need to focus ourselves. And today we're going to address just some routine U.S. application practices that are common here, but may be either not permitted in foreign jurisdictions or subject to restrictions that are not present in the U.S. So one common practice in the U.S. is reference to another document for technical details. That's typically called incorporation by reference. So you'll refer to a patent application or some non-patent literature or another patent that has some relevant technical information. Ideally, you won't need that for your application. It's partly background, but sometimes you do need it. Another common practice in the U.S. is submitting additional data after filing the application. This is often done to support unexpected results, or to provide technical arguments to support some assertions in the specification. And this is often an affidavit of the inventors, and it presents technical arguments rather than legal arguments. So these things are all routine in the US, but may not be possible in other countries. And we're going to look today at some examples from Europe, Japan, and China. But before we get to that, one of the, just as a way of some context, one of the reasons that some of these issues arise is the way obviousness is handled in the U.S. versus other countries. So in the U.S., the Patent Office focuses on the clauseless prior art and whether the differences between what's claimed in the prior art are obvious to this hypothetical person of skill in the art. In Europe and many other jurisdictions, generally they take the problem-solution approach. They identify effects associated with the different features, and they express the step of going from the closest prior art to the claim subject matter in terms of a technical solution to an objective technical problem. And so the EPO believes this is a more objective approach, and consequently, often they will give less weight to inventor declarations, even when they're allowed to be submitted. With that said, we'll start with Europe, and we're talking about something called implicit disclosure. So you're not allowed to include new matter in your application, but sometimes you want to rely on something that's not expressly written in your specification, but you believe that it logically or scientifically flows from what you've expressly written, and that concept in Europe is called implicit disclosure, and it must be clearly and unambiguously be implied by what's explicit. So explicit is the actual words in your application, and implicit is the scientific concepts that implicitly flow from that. So we'll look at one example where that was found to be not present. This is a claim to a color encoding composition, and it requires an ultraviolet light absorber in an amount of between 0 and 5% by weight. So a very common type of composition claim, common type of way of claiming a weight range. So the claim encompasses having no UV absorber, which is the 0, the lower bound of that range. And so the question is, would a person of skill in the art clearly and unambiguously derive from the specification that UV absorbers are optional? And in this case, the EPO said there was no implicit support for this feature. And now, why was that? Now, of course, we don't have the specification in front of us, but a summary of what the applicant argued is as follows. They said that the invention only, quote, encompassed compositions with UV absorber, but that wasn't the invention itself. It was only a preferred embodiment. And that there was a sentence in the specification that said that the composition could protect from visible light and or ultraviolet light. And because you don't need a UV absorber to protect from visible light, it would be clear that a UV absorber is optional. The EPO disagreed with that argument. They said the preferred embodiment had a UV absorber. Also, the specification said that the UV absorber was typically present, and they quoted that word typically in an amount of 0.5 to 5 weight%, which does not include 0, and also that the specification overall mentioned UV absorber everywhere, and requiring UV absorber was consistent with the specification. So the takeaway from this is, if something is optional, you should generally expressly state that and don't rely on any kind of inherency or implicitness arguments. Okay, post-filing data. In Europe, you can submit additional data after you file your application, but there are caveats. The data you submit can't be the sole basis for establishing that you solve the problem. In other words, if the application is missing certain technical details that shows that you've provided a technical solution to the problem, the data you submit after filing can't be the first time you show that. For example, here in the biological sciences, there's a claim to a polynucleotide encoding a polypeptide having GDF9 activity. GDF9 is growth differentiation factor 9. It's required for proper functioning of ovaries and human egg development. And in this case, the application only stated GDF9 was expressed in ovarian tissues. There was no functional data provided. And one of the things the applicant tried to do was submit post-filing data, but the EPO did not accept it. First, the EPO pointed out that GDF9, the functions that the applicant speculated for GDF9 were based on proteins that had different sequences and structures, and it had very, very low sequence homology. And secondly, the post-filing data was the first showing that of what the function of GDF9 was. There was nothing like that in the original specification. So for those reasons, the post-filing data was not allowed. So, I guess the obvious takeaway is you need to include some data in order to make arguments about what your antibody or compound or whatever your biological agent does. Finally, in Europe, we'll look at incorporation by reference. If you've read a patent or patent application, you've seen text like this in there. Application number so-and-so is herein incorporated by reference in its entirety. This is very, very common and routine in the US. We don't think twice about it. But what happens if the subject matter is essential to your invention? Normally it's not, but sometimes it is. Can you include in your specification? Well, in Europe, you will have to, because in the EPO will make you delete that sentence. The incorporation by reference text will have to be deleted from the specification. You'll actually have to put the subject matter into your application. And now here comes a list of requirements. You need to, that subject matter has got to solve the technical problem, has to implicitly belong to the description as filed, and has to be precisely defined and clearly identifiable in the reference. If you're going to find yourself making arguments about how it's precisely defined and clearly identifiable, meaning that it may be not so precisely defined, you may run into some problems. But if that's not enough, there are even more requirements. So the reference has got to be available to the PO on or before the application filing date, and the reference document's got to be available to the public no later than the date of publication of the application. So this is an example where applicant tried to rely on 3 documents incorporated by reference. And references 2 and 3 you see had publication dates that were after the publication of the European application, and so they were not allowed to be incorporated. And another reference was not set in the priority document, so it served as prior art. The point of the slide is not for you to memorize or even really consider these rules that much. It's really to illustrate that unlike in the US, there's a lot of other requirements that have to be met before a document, before subject matter from a document can be incorporated by reference in Europe. Okay, well, now we'll move to Japan. Generally, to get full claim scope, you have to show that the scope of the claim could be realized by any of the embodiment, any working examples in the application. And in order to do that, you need experimental data. Without experimental data, if it's purely or largely speculative, there are going to be issues in Japan with regards to how much support you get. You may not be able to get any claims if you don't have sufficient experimental data, or very narrow claims. So how much support do you need? Here is an example in Japan where it's a process for making a polarized film, and when the film satisfies the certain conditions, you get a stable polarizing film with excellent polarizing properties and durability. So the original specification in this case only had 2 examples and 2 comparative examples. So it basically means 2 working examples to support the 2 equations in claim 1. And the Japanese High Court said not supported because you couldn't conclude that any embodiment, basically that any example that you chose satisfying the 2 equations would get the target effects. And they did not accept any experimental data after filing. So that means that all that data that they submitted should have been included in the original application. So with Japan, it's kind of easy. It's very strict. There's no post-filing data, and there's no incorporation by reference. And especially for pharmaceutical biological applications, if you fail to include things like efficacy data in the application at the time of filing, you can dramatically reduce the odds of you obtaining claims or getting very, very narrow claims. In China, they have a slightly different view of support than in the US. So in the US, written description, there's a written description requirement for the specification. Basically, what you put in your specification should inform a person of skill in the art that you had possession of your invention at the time of filing. So it should have sufficient details about the components and maybe how to make them. Things like that tend to show that you had possession of the invention. China has a slightly different view. They believe that the claim solution should be directly reached or properly generalized from the specific examples in the description. So there's a big focus in China on the examples. So what does that mean in practice? In practice, that means you should have lots of specific embodiments, which means lots of working examples, as many as you can, preferably at least 3. If you have less than 3, then Chinese examiners can give you can reject your claims for lacking written description, and ultimately you may only be able to get claims to a very narrow scope, narrower than you're actually entitled to. China does allow incorporation of reference in theory, but it's more limited in the US. The cited reference must be published before the filing date of the application, or be a Chinese application published before the publication of the application issued, which means that you can't incorporate subject matter from the priority application. And any technical information required to satisfy the written description requirement should be in the application. It's very difficult generally to convince a Chinese examiner to allow an amendment to the description. They're just going to say it's new matter and it's not getting in. Interestingly, China is also more cautious about what what is known in the art, what are known techniques or what's common sense. So it's harder to argue in China that a person that's scared of the art would know that something operates a certain way, or a certain substance or combination of substances have a certain property. They're much more circumspect about that kind of thing. So if that's not in your specification, you can also run into issues there as well. I'll give you a post-filing data example. Typically, they will not consider supplemental data after filing, but in some cases, it may be allowed. So it's not a hard and fast rule like in Japan. It may be allowed to confirm statements in the specification with respect to the function. This is often occurs in chemical cases. So this means that you had to have something in the specification that's filed, and you're just merely supplementing it. If it's just coming out of, if it's the first time the concept or the data is presented, it's likely not going to be admitted. So here's an example. Boehringer Ingelheim filed a patent application directed to compounds for inhibiting Hep C. Submitted amended claims to just 4 specific compounds, and they also submitted post-filing data showing superior oral bioavailability. But that data was not accepted in China because there was no experimental data to support oral bioavailability in the original application, and also there were no experimental protocols. The experimental protocols, rather, in the post-filing data were not described in the original application, which makes you wonder if they would have mentioned something about those protocols in the original application, even without presenting specific experimental data, whether that would have affected whether that data was ultimately admitted or not. I'm not sure whether that would have been the case, but it's instructive that to the extent possible, whatever you can. Even if you don't have experimental data, if you can put some details about experiments that would ultimately help highlight a superior property of your compound or whatever it is, it's helpful to put it in there. So to conclude, some tips for ensuring you have application support. The takeaway message: be explicit, right? Put it all in there. Be aware what's optional and what isn't. If something's optional, it's very important to say that it's optional. Don't if you're having to argue that it's optional, you may not be able to get away with it, frankly. Consider what properties of individual features are important, not necessarily essential to the intended functioning of the invention. And when we're working with applications, we become so intimately familiar with it, we forget to. It's hard. You're just too caught up in it. So, for example, if you have a layer that has an opaque pigment in it, can you say that such a layer is not transparent if the words "not transparent" don't appear anywhere in your specification? To us, as drafting it or as the inventors, you may think it's obvious, but if you don't put it in there, it may be difficult to rely on that feature, especially if you need to rely on it. If it's not written in there. Thirdly, don't rely on incorporation for reference. Everything you need to practice your invention has got to be in your specification. Even if you're using some sort of prior art process, that don't rely on the steps in a prior art reference. Put those steps in your specification, because otherwise you just create more potential headaches for yourself. And finally, fourthly, put experimental data in the application to the extent possible. There are obviously challenges when high stakes, pharmaceutical patents, where you don't want your competitors to know your data, but some data is better than no data. And finally, try to have at least 3 working examples to ensure that you have to ensure you'll get the full, or at least help ensure you'll have the full support for the scope of the claims that you want. And with that, I'll take questions.
Yeah, thanks, Dennis. We'll give everyone a minute here. If they have any questions for Dennis, please feel free to use the Q&A or chat feature. Our next presentation is going to be in January 25th at 1 p.m. Central. This one, we're going to take a look at top 3 IP issues for corporations and universities. That's specifically going to be relating to the bio and chem space. We'll give a little bit more time if anyone has any questions here. We have one question. Regarding the 3 examples, any advice on suggesting one is preferred?
Saying I would not characterize anything as preferred. That would be my advice, because it just gives the examiners an excuse to limit your scope or otherwise hobble you. So our advice is never say anything preferred. It's just one embodiment.
All right. Well, I think that's all we have. If anyone has a question and would like to talk with Dennis offline, you can certainly email him. Again, a copy of the slides and a recording of this presentation will be sent via email either later this afternoon or tomorrow. Thank you to everyone who was able to attend today, and I hope you have a great day and a good holiday. Cheers.